rolling.
Okay. This is what, part 5?
Part 5.
Of freedomfirstparty.net. We have discussed a lot of congressional documents. We're going to get into some more. We're going to get into the private attorney general side of this thing. Here on the board, Congressional Records again, 39th Congress, Session 1, Chapter 31, 1866. April 9th, 1866. An act to protect all persons in the United States and their civil rights and furnish a means of their vindication. This is what Congress created for the Private Attorney General Act. Remember what we talked about? Article 3, Section 1, created the courts, created the building, never filled them. This is the law that gave us the power and the authority to go after these people. All of us have it. This is why they created a bar association, to bar us from coming in. They knew if the people would ever understand that, we'd be able to start taking them down and start taking them out under civil rights violations. But Congress created this. It isn't until the last few years where people were made aware of this. You've had other people that talked about it, but they didn't get into the in-depth side of this thing. They didn't really want to explain it. Well, we don't want the people to know because we don't want it misused. That goes back into a lack of training and what they expect out of the people. I get people come up and ask me, Rod, do you think I can make a private attorney general? The question is, can you walk, talk, and explain this? Can you sit back and support it? Can you write your own paperwork? If you get into a corner with a judge, can you sit here and corner this judge and nail him on this? These are all part of the things that we have to bring up. Okay? The bounty hunter side of this is under congressional acts. It's a bounty hunter of Bounty Hunter of Responsibility Act of 1999 and 2005. It goes in and shows you as a bounty hunter. Now, ladies and gentlemen, there is a difference.
What just happened?
There is a difference between a bounty hunter and a bail bondsman. The states have come in and passed laws that we don't want bounty hunters in our state. We will allow bail bondsmen. The difference is a bounty hunter works under the private attorney general side of this thing. Private attorney general works under Title 42, 1988. Bounty hunter works under Title 42, 1983. Civil rights violations. As a private attorney general, we can bring the claim in. We can go after the bounty hunting side. Works under Title 18, 241, 242. What this goes in allows us to do is operate under color of law. That is the most significant thing that we can operate under, is color of law, going after these people. I want to sit here and pull some documents up because I want to show you the significance of this. Bounty.
I thought operating under color of law was a bad thing.
Was illegal under color of law.
Well, that's exactly what they're operating underneath. That's the whole point. That's our problem. Their texts will point blank tell you they are operating under color of law. Their text will tell you this. This is the significance in this. That's why what we're showing here is vital. That's why what we're showing here is significant in this. To clarify, that a bail bonds, surety, and bounty hunters are subject to both civil and criminal liabilities for violation of federal rights under existing federal civil rights laws and for other purposes. as a bounty hunter, you got to watch what you're doing. You can't just be kicking in doors, but yet they have gave them rights and them privileges. A bail bondsman can kick in your door without a warrant, handcuff you, and drag you out of that house. But here's the law says they got to come in compliance. The state has allowed them. In general, the purpose of Section 1979 of the revised statutes of the U.S.C. Code, Title 42, U.S.C. 1983, Section 242 of Title 18, the United States Code and other acts of Congress providing civil or criminal liability for the deprivation of federal protected rights under what color of any statutes, ordinance, regulations, customs, or usage of state. Surety and bail bonds, an agent of such sureties, or any bounty hunter. Ladies and gentlemen, stop and think here what we're talking. The courts use bail bondsmen because they put a surety bond on you that you will show up to court. If you skip, your bail bondsman hunts you down and tracks you down. A bounty hunter works on the same principle of surety bonds. Now think about what I'm going to sit here and say. Doesn't judges and lawyers have surety bonds when they take their position? Yes, they do. This is why they're outlawing bounty hunters and only allowing bail bondsmen to work. Thing of it is, I operate under the 14th Amendment, Section 4. I'm going after the public debt side of this. We're working under the constitutional as a constitutional bounty hunter. We're going after their bonds. The thing is, we're not asking the government to turn around and pay collateral. We want their insurance company to pay. We want them to pay. They're no different than a drug dealer. When you bust a drug dealer, what do you take? You confiscate everything. Who gets the money? It doesn't go into the public debt. It goes into the police department. It gets kicked back to the judges. It goes to the lawyers. It goes into their charity fund. And what's their charity fund? Themselves. This is why this is significant. This is why I chose to run on this side of the fence. Because we go after the 14th Amendment bounty on these people, we can go after their property. Under Title 31, United States Code, under finances, 3729, false claims. 2/3 of your finding goes to the Treasury. 1/3 goes into your pocket for a reward. It's a bounty. You get paid for doing this. The difference between a bail bondsman and a bounty hunter is that one's working for the court and the other one's working for the people. A bounty hunter works for the people. Private attorney general works for the people. I just sit here and showed you the laws that created both positions. Congress gave us these positions. Congress sat here and said, people, citizens, you have the right to walk in and prosecute. You have the right to sue. You have the right to go after any color of law violations. That's why the court system and the attorneys hate us. That's why they don't want us walking in. Now, let me bring something else up to you, because this is the beginning of this. This is the history of it. This is the history. Let me show you something else with what we're doing and how we're going to go back and do it. All right. Joe, Paula, you guys are having an issue with the court system. Whether the defendant has been unconstitutionally prosecuted and imprisoned under the repealed section of A1 of Title 21 of the United States Code, Section 841. What is Title 21, Section 841? Possession. possession of marijuana, possession of drugs. Whether the defendant has been unconscionably prosecuted and imprisoned under the repealed section of A1 of Title 21 under United States Code, Section 841. Title 21 United States Code, Section 841, as printed in its original form of 1970 edition reads, 841s, prohibit acts, A, unlawful acts, except as authorized by this subsection. It shall be unlawful for any person knowingly or intentionally to manufacture, distribute, or dispense, or possess with intent to manufacture, distribute, or dispense a controlled substance, or create, distribution, or dispense, or possess with intent to distribute or possess a counterfeit substance, see 1970 section statute Exhibit 2, which is part of the paperwork. Congress enacted the Comprehensive Crime Control Act of 1984. Through its enactment, the Public Law 98-473 was introduced a number of changes into the administration of federal criminal justice. Effective date and saving provisions of 1984 amendment, amendments to Public Law 98-473, Section 224A, that affected on the first date of first calendar month, beginning 36 months after October 2nd, or October 12th, 1984. Appliance only to offenses committed after date taking of Section 211 to 239 of Public Law 98-473, and accepted as otherwise provided therein. See Section 235 of the Public Law 98-473 as amended. Set out as a note under section. It goes through here. Bottom line boils down to, this gets back in, it's a complete congressional record. It shows that possession laws was repealed. Dispensing was repealed, never put back into full force and effect. That is the significance of what we're sitting on right here.
Does every lawyer know that?
Every lawyer knows this. Every prosecutor knows this. Every judge knows this. The system created the law.
Read the section where they actually say it's repealed.
That as a result of the repeal of the saving provisions of Public Law 98-473, the Section 105A2 of Public Law 99-570, and by it not being reenacted by Congress, Westlaw has clearly printed that Title 21 of the United States Code, Section 841A1, that was to be saved by the saving provision was taken effect on November 1st, 1987, was never executed to the text of the section of 841, and therefore that reason Title 21 U.S.C. Code Section 841A1 does not have the unlawful act section. Unlawful act section means it's not unlawful, of the statutes as printed in the 2002 edition of Title 21 United States Code Section 841. The defendant has truly reported and shown that he has been unconstitutionally prosecuted and imprisoned in violation of due process of law by being prosecuted under the repealed statutes.
Great. Great.
What happened to that case? Did he sue for his rights?
Well, I don't know. We got our hands on this. One of our people got our hands on it. Right there in that last line, the defendant has truly reported and shown that he has been unconstitutionally prosecuted and imprisoned in violation of due process of law by being prosecuted under a repealed statute.
Fantastic.
But what happened to the guy after?
Well,
He won.
he won his case. They dismissed it. He got out of jail.
And hopefully,
Okay. No, we don't have the whole thing where he went back and he hired a lawyer and he went in and did a lawsuit and he brought it. That is not the issue.
Right.
The issue here is
He won.
he won. Here's the law that says that law was repealed and that Westlaw printed it and failed to state it was repealed, and prosecutors have been using it because they're not coming back in and putting in the whole evidence of what's going on in these court cases, and these lawyers know it.
And they're clearly acting under color of law.
Clearly acting under color of law. Now, let me bring up something else to you. The Dick Act of 1902. The Dick Act of 1902, also known as the Efficiency of Militia Bill, H.R. 1165-4 of June 28, 1902, invalidates all so-called gun laws. It also divides the militia into three distinct and separate entities. The three classes under H.R. 1165-4 provide for the organized militia, henceforth known as the National Guard of the States, Territories, and District of Columbia. The unorganized militia, and the regular army. The militia encompasses every able-bodied male between the age of 18 and 45. All members of the unorganized militia are to have absolute personal right and a Second Amendment right to keep and bear arms of any type and as many as they can afford. We are going through a gun crisis. Obama is going to the UN. The only thing that the UN can do is go to the police officers out on the street and say, hand over your sidearms. Go to the FBI and the federal marshals. Hand over your sidearms. The UN can only go to those public officials that come under the International Organization Immunities Act, which we talked about here earlier. They cannot disarm the American citizens.
Or the military.
Or the military. They cannot. The Dick Act of 1902 cannot be repealed. Unlike Title 21-841, it was repealed. They can't repeal the Dick Act because it would violate the Second Amendment. Let me bring up to you, because there seems to be quite a bit of misunderstanding here of the term firearm. Firearm. A shotgun having a barrel of 18 inches or less than, a shotgun having a barrel of less than 18 inches in length. A weapon made from a shotgun, if such weapon has modified, has an overall length less than 26 inches, or a barrel length less than 18 inches. That's a firearm. A weapon made from a rifle, if such weapon is modified, has an overall length less than 26 inches, or a barrel less than 16 inches in length. Any other weapon as defined in this subchapter, a machine gun, a muffler or a silencer for any firearm, whether or not such firearm is included within the definition. Ladies and gentlemen, a rifle is not a firearm. A shotgun is not a firearm. A revolver is not a firearm. A semi-automatic pistol is not a firearm. It's not modified.
An
M16, AR-15. Under the Dick Act, we are to have all of these. That Dick Act just tore this bill apart because now they're trying to create laws that says you can't have such thing, and the Dick Act comes right back in and repeals this. You can have a sawed-off shotgun. You can have a sawed-off rifle. You can have a fully automatic machine gun. You can have a silencer. The Dick Act comes back and repeals it. But you know what? Lawyers won't bring this up in the courtroom. Why? Because it's highly profitable not to. Because when they sit down and they bust you for a firearm. They're using that in a general sense. If you come into the legal definitions, this is Title 27 CFR. This is under Section 479.11 of the Code of Federal Regulations. This comes back and shows you exactly what it is. There it is. Title 27 CFR 479.11. Meaning and terms. Definitions of words. Between the Dick Act, between the drug laws, between the private attorney general, between the bounty hunters. Ladies and gentlemen, we have laid out enough information to all of you to be able to come back in and stand your ground with all these people. This is a historical background of what we're talking about. This is history. All of this came out of their documentation. Here is the 1867 Congressional Record. This is the Attorney General's opinion. This is the one that come in and clarified. Here it is, cite as of 12 U.S.C. Attorney General's opinion 182. You get into their books. United States Attorney General, the Reconstruction Act, June 6, 1867. It comes down and lays out everything in here. It goes in and shows that we're under military law, 1867. It has not changed. We're still under the same military law. This document comes in and tells you how they're supposed to try us, and they're violating it. They're supposed to actually be bringing us into a military court. We're supposed to be going before military tribunals. They're not doing it. They're playing both sides of the fence. When it's convenient, it's Constitution. When it's not convenient, they're running military. They're suppressing all of our evidence. They're suppressing everything that we're doing. These documents are going to be given to Joe and Paula to put up on their sites, ladies and gentlemen. There is roughly about 145 gigs of information of all kinds of congressional records, all kinds of congressional documents. Everything that we're doing, the duties and powers of the state. Now, I want to remind you people of something. Courts have ruled. The police officers have absolutely no obligation to protect the citizens. They have no obligation to protect the citizens. Not their job. If you dial 911, they don't have to show up. That's not their job to show up. If they choose to, that's fine. If they don't, well, who cares? Not my job. But yet they're being paid. If they don't have the job to protect me, then they don't have the job to stop me. Ladies and gentlemen, that's where it's coming down for education on our side of the fence. Am I saying that there are no laws? No, I just went down through a whole bunch. There are laws. Their side's not following them. They're not following their own rules. They're not following their own regulations. They are not following anything on their side to preserve and protect the rights of the people. Throughout history, records have been kept in Congress. Whatever was set by executive order. Now think about what I'm going to sit back and tell you. How many times have we read executive orders and the president uses, by the power given to me by the Constitution, I have the authority to exert my executive order. Where in the Constitution does it give him the authority to override the Constitution?
No place.
Where does he get the power to sit down and claim the authority of the Constitution and then override it? Nobody's ever given that any thought. Every time I have heard this, I sit back and I've read it, I've chuckled to myself, what a joke. That's an act of treason. Obama is claiming the authority under the Constitution to disarm the American people. Wait a minute. Forget about the Second Amendment. Second Amendment here. Wait a minute. Bill of Rights. You can't disarm me. What about my due process? What about the Fourth Amendment? What about the Fifth? What about my Sixth Amendment counsel, where I pick somebody, not you pick. I pick somebody. What about the Seventh Amendment? Right there, jury of my peers, not yours, mine. These people want to claim the Constitution when it's convenient. But when it comes right down to upholding it, they don't. This is the significance of the educational program of what we're trying to get out. Make people aware. Get people knowledgeable. Get people to understand what your rights are. Because if you don't understand your rights, you have no rights. Understand the Federal Reserve Act of 1913. When they sat down and they passed it, they created Federal Reserve notes. That Federal Reserve note is not money. It's a mere promise to pay you. I showed you the Congressional Records. I showed you that it is the credit line of the people. You are the means of how this country operates. Several court cases, Credit River decision out of Minnesota came back in where an attorney took in the bank, got the bank to admit they don't lend money. They lend credit off your signature. And whose credit is it? Your credit. Where's that credit come from? Your birth certificate. It comes off that Social Security account. That's the credit that we're supposed to be getting. They're supposed to be discharging, not turning around and saying, here, oh, by the way, we're going to give you the credit line, but we want you to pay it back, so sign the mortgage. Ladies and gentlemen, what is the difference between you having a savings account and going into your savings account and pulling money out of your savings account? Does the teller sit there and say, okay, Mr. Klaas, we're going to allow you to have money out of your savings account, but you need to sign this mortgage because we want you to pay it back plus interest into your savings account. Now think about the logic of what I'm sitting here telling you. If the birth certificate account was set up as the credit line for the American people, for us to be able to access, for us to be able to buy, because they took our gold and silver off of us. And they created Federal Reserve notes, which you and I are not allowed to have, or was not supposed to have, put it that way. Not supposed to have. That was never supposed to have been given to us. All we had to do was sign our name. Write your name across the bill, give it to the bank. That bank was supposed to sit down and deduct it out of your account. That's exactly what it gets into. That's the point of that's the problem that we're having here. This is why we're having such an issue in these courts. This is why we're going to jail. It's highly profitable. I want to show you something else here. Title 12, 411. Remember here earlier, I sit here and I showed you the Federal Reserve Act of 1913. Even under their own statutes, it says Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advancements to Federal Reserve banks through the Federal Reserve agent as hereinafter and set forth, and no other purpose is authorized. Did we read that out of the Federal Reserve Act of 1913? The said note shall be the obligation of the United States and shall be redeemed at all national and member banks and Federal Reserve banks, and all taxes, custom, and public dues. They shall be redeemed in lawful money. Wait a minute. Shall be what happened to the word gold?
That is lawful money.
But the Federal Reserve Act had gold is lawful money. This is the difference here. This is color of law. Let me come back in. Let me show you the difference. Because, ladies and gentlemen, this is the scam that they're running on you and I. This is what they're doing to us. I got to put it in the wrong pocket. Federal Reserve Act. Because this is where the color of law comes in. This is where the difference comes in, why they do not want us to bring these books into the courtroom. Because these represent the real law. These sit here and represent the real side of this. The reason why we're making a significance, because, ladies and gentlemen, it's all in their wording. It's all in their wording. They shall be redeemed in gold on demand at the Treasury. The said note should be the obligation. Okay. They shall be redeemed in lawful money. Yeah. They changed the wording in the law. That's why this is called color of law. This is why they're using it in the courtroom, because it allows them a wide room for discretion, and it's vague for them to make whatever determination they want to make in that courtroom. These were copyrighted. USC codes are copyrighted. Statutes at large, I believe they are not. Therefore, it's the real law that can be brought in. That's why they don't want it brought in.
Can you explain copyright?
Do what?
Can you explain copyright?
Copyright means that whenever the publishing did this, they have sole exclusive use over this. It was strictly for them to sit down the way they worded it. If you want to use copyright, you have to pay for the privilege of using it or give them recognition. This is what we're doing. We're giving them recognition. We're sitting here saying they created this.
Also, we can say, since they use taxpayer dollars to copyright it, they can't keep us from using it.
Exactly right. But again, taxpayer dollars. Are you talking them Federal Reserve notes? That is a mere promise to pay someday? See, this is where the problem's coming in. We use words like this, and we're not comprehending the Federal Reserve Act. Federal Reserve notes was internal currency. State of emergency stripped us of gold and silver. Social Security Act put a price tag on us on $1.8 million. Alien registration created a birth certificate, shows that you're born alive. You're dealing with an IRS case. They're getting you because you failed to file. File what? What did I forget to file? Well, you forgot to file your tax return. Tax return on what? Well, you got wages. No, I didn't. What I got was a promise. I didn't get wages. All I got was a check. And that check has been sold because it had my signature on it. Has been securitized on. Why aren't you going after the people who sold my signature? Why aren't you going after the people who bought it and securitized? Because I haven't been paid. IRS don't want to get into this debate. The courts don't want to get into this debate. You're walking into a traffic issue. You're being charged for sitting down and having a traffic violation. You don't meet the qualifications. You don't meet the qualifications to sit down and have a driver's license. I'm going to sit back. I'm going to show you what we filed in to the administrative court up here in Raleigh on driver's license issue. Ladies and gentlemen, again, we're coming back in and we're playing with words here. But remember, you and I did not create these words. You and I did not write the laws on any of this. As you're seeing here, because one reason why we're doing it, you're seeing there's a lot of information on this hard drive. A lot of files. A lot of files within files. There is a lot of information that you're dealing with. DOT, Department of Transportation. Part of the problem is that you guys are coming in and you're wanting to use case law and you're wanting to use the Constitution of why I don't have to have a driver's license. Let me bring something up to you. Let me bring your attention up to this. Stop it. Title 49, United States Code. Subtitle 6, Part B, Chapter 313, Section 31301. Definition. Commerce means trade, traffic, and transportation. In the jurisdiction of the United States between a place in a state and a place outside of the state, including places outside the United States or the United States that affects trade, traffic, and transportation described in subclause A of this clause. A vehicle's weight rating or gross weight of at least 26,001 pound, whatever is greater or lesser gross vehicle weight rated or gross vehicle weight of Secretary of Transportation prescribed by regulations, but not less than a gross vehicle weight of 10,001 pound. This is what they're classifying for driver's licenses.
What does a car weigh?
Do what?
What does a car weigh?
A car weighs out about 5,000 pounds, 3,000 pounds. Motorcycle weighs out about 800 pounds or 700 pounds. Driver's license means a license issued by a state to an individual authorizing the individual to operate a motor vehicle on the highway. Employee means an operator of a commercial motor vehicle, including an independent contractor when operating a commercial motor vehicle who is employed by an employer. Now, listen to the words. Commercial motor vehicle. Now, think about what I'm going to sit here and ask you. Traveling up and down the highway, you pass these little substations, says commercial trucks, commercial vehicles pull in. They're weigh stations. Commercial. Why aren't the cars going in there? Why aren't the cars going off and getting weighed? Because we don't come under commercial. We're only commercial when it's convenient. This goes back into what we're sitting here teaching and what we're getting into, what we're explaining. Employee means an operator of a commercial motor vehicle, including an independent contractor when operating a commercial motor vehicle, who is employed by an employer. Now, the question is, who is an employer? Well, let's look at it. An employer means a person, including the United States government, a state or a political subdivision of a state that owns or leases a commercial motor vehicle or assigns employees to operate a commercial motor vehicle. You remember what we talked about under that state of emergency? How everything is turned over to the state? Your car's turned over? This is how they're nailing us. It's under their laws, their regulations. On one side of the fence, they're sitting down saying, well, the state owns your car, therefore you come in compliance. Therefore you have to have a driver's license. Well, if I am driving in commerce, shouldn't I get a paycheck? Where's my time clock? Where's my insurance? Where's my vacation pay? If I'm considered an employee, isn't there some benefits on this side of the fence? Aren't you supposed to be paying for my insurance? Aren't you supposed to be making the car payments? Aren't you supposed to be doing the maintenance? All I am is just a driver. This is the point that we're getting into with these people. Now, Title 49, Subchapter 6, Part B, Chapter 315, 31501, definition in this chapter. A migrant worker means an individual going to or from employment in agriculture as provided under Section 3121G of the Internal Revenue Code of 1986. You remember us sitting here talking about the Guardian ad litem? How we come under the Department of Interior? We are a natural resource. Where do you think agriculture comes in at? Think about it. I didn't write this stuff up, they did. This is how they're hammering us. Motor carrier, motor common carrier, motor private carrier, motor vehicle in the United States has the same meaning given to these terms in Section 102 of this title. Means a person, except a motor common carrier providing transportation, reference to section 13501 of this title by a motor vehicle, except a passenger automobile or a station wagon, for at least 3 migrant workers at a time to or from their employment, but does not include migrant workers providing transportation for migrant workers and their immediate families. They wrote the laws, ladies and gentlemen. They wrote the laws. Identification of a motor vehicle, Title 49, Subchapter 6, Part B, Chapter 315, 31504, definition of motor vehicle, Secretary of Transportation. Ladies and gentlemen, everything that we're dealing with says issued and required the display of identification plate on a motor vehicle used in transportation providing by a motor private carrier and motor carrier of immigrant workers subject to section 31502 of this title, except a motor contract carrier, and required of each of these motor private carriers and motor carriers of migrant workers to pay the reasonable cost for the plate. These are all of their laws. These are all of their regulations.
These are federal, right?
Do what?
Federal.
Yeah, these are all federal.
They're going to say state of New York has different ones.
State of New York comes under Title 23 USC under federal grants because the state is being given federal funding to implement federal laws on driver's license issues. Therefore, if you read this, civil penalties, listen to what it says here. Hearing requirements. The secretary, that's right here, under 49, subtitle 3, chapter 51, 5123, civil penalties. The secretary may find that a person has violated this chapter or a regulations prescribed or order. Now, wait a minute. Now, doesn't regulation and order sound awful familiar with the state of emergency clause where they're pulling their words and agency? Special permit or approved issued under this chapter only after notice and an opportunity for a hearing. The secretary shall impose a penalty under this section by giving that person written notice of the amount of penalties. Wait a minute. Where does it say a judge? Where does it say a local court? This is why we're being scammed. This is why they don't want us walking in here. Now, it continues. Penalties and consideration. In determination the amount of civil penalties under this section, the secretary shall consider the nature, circumstances, extent, and gravity of the violation, with respect to the violator, the degree of culpability, any history of prior violations, the ability to pay, and an effect on the ability to continue to do business. Wait a minute. How many judges have pulled people's licenses to keep them from working? They're interfering with their income. Here is the issue. They cannot interfere with your business. They cannot interfere with your means of income. They're doing it anyhow. Now, after Secretary of Transportation pulls your license under Title 49, Subchapter 3, Chapter 51, 5127, Judicial Review, Filing and Venue, except as provided in Section 20114C, a person adversity affected or a grievance by a final action of the secretary. Don't say judge. It says secretary.
Is this the administrative?
Yes. Under this chapter may petition for review of the final action in the United States Court of Appeals of the District of Columbia. This is a federal court. This is not your appeals court. This is not your local courts. These are the issues, ladies and gentlemen. These are the issues. Or in the Court of Appeals for the United States for the circuit in which the person resides or has a principal place of business. The petition must be filed not more than 60 days after the Secretary's action becomes final. Ladies and gentlemen, we have been scammed to the fullest. All this stuff has been withheld, this information, and it's kept by the Communist Party. The lawyers, the prosecutor, and the judges know this. They understand this. When you try to bring in, we're not under federal regulations. We're not under federal regulations. We don't come under federal laws. Ladies and gentlemen, let me sit here and show you something. These are the state laws. Well, I want to show you something here in a minute. The United States Code, Title 23, Highway Safety Act, 402. Each state shall have a highway safety program provided by the Secretary designed to reduce traffic accidents and death, injuries, and property damage resulting therefrom. Such program shall be in accordance with uniform guidelines promulgated by the Secretary. Such uniform guidelines shall be expressed in terms of performance criteria, and additionally, such uniform guidelines shall include the programs: administration of state program, administrative requirements. The Secretary may not approve a state highway safety program under this section, which does not provide that the governor of the state shall be responsible for the administration of the program. The governor has to sign this into effect. They have to. They're getting federal funding. They're getting federal grants out of this. Stop and think what I'm going to sit back and ask you. Whenever you go from state to state, do you have to stop at one state and get a new driver's license to go through that state, to go to the next state? No, you do not. That means driver's license or interstate. That means they're federal. If you are a doctor, you're a nurse, you're a barber, you want to go from state to state, guess what you have to do with your license? You have to apply for a new one in each state. Why? Because they're state-oriented. Driver's license or interstate, they're federal. The governor agreed to this in order to hand out driver's license. Now, they also agreed to this. Under Title 23 CFR, National Highway Traffic Safety Administration and Federal Highway Administration Department of Transportation, under Title 23 CFR, you remember hearing the words political subdivisions? Participant in the State Highway Safety Act program? Under Title 23 CFR, Highway Safety Act, Part 1250, Political Subdivisions Participation in State Highway Safety Program. Section 1250.2, Purpose. The purpose of this part is to provide guidelines to determine whether a state is in compliance with the requirements that at least 40% of all federal funding apported under 23 U.S.C. 402 will be expanded by a political subdivision of such state. That means your local community is required to get 40% of the federal funding that they're taking off all these traffic stops, and your political subdivision is being ripped off. It's being embezzled. Ladies and gentlemen, I am not the one who wrote this stuff. All I'm doing is showing you where it's at, where it's located, for you to go back and do your own research, draw your own conclusions of what we're talking about.
How is the bounty hunter paid?
Do what?
How is the bounty hunter paid? He obviously
Through rewards. Bounty hunter is paid by going in and getting a prosecution, getting a conviction on these people. That's why they don't want us convicting them. That's why they're trying to come back and claim all these immunities. This 40%, ladies and gentlemen, is part of what we're going after, because the cops are not doing the job that they're supposed to be doing. Oh, they're stopping you, all right. But they're not getting that 40%. The prosecution in the court is hiding it, so is your attorneys. These guys are being played as pawns. These guys are risking their life out here so the lawyers and the judges and the prosecutor can get richer and richer and richer and embezzle more and more, because they're not aware of the birth certificate side. They're not aware of the bankruptcy. They don't have a clear understanding of all this. But they're good little sheep.
I bet a lot of them are learning.
The good little sheep, because if you go back and check, a lot of them will sit back and tell you they got an IQ of 87. Anything over that, they do not want in. Why? Because they're capable of thinking and they're capable of comprehending exactly what we're sitting here talking about. They don't want them to comprehend. They don't want them to understand the fraud. Thank you.